All right, the first case to come before the court this morning is State of Ohio versus Neil Miller. The state has waived in this case. Mr. Miller, you'll have 15 minutes to argue your, I'm sorry, Mr. Miller. Oh, not a pro se case. Mr. Linehan, you'll have 15 minutes to argue your position if you wish to take that time. The arguments are being visually and audibly recorded to be posted online, so please keep your voice up, remain behind the podium. I would caution you don't mention the name of any victims or children, but I don't think that's applicable in your case, and we are ready to begin when you are.
Thank you. May it please the court, Your Honors, good morning. I'm Attorney Patrick Linehan on behalf of Mr. Miller. This case, Your Honor, in 30 years of practicing law and trying hundreds of cases, including hundreds of jury trials, this is the first case in which I've ever had the state, after concluding a trial, take a set of documents and say, we move to admit those documents without even presenting them in the case in chief. The prosecution asserted that this particular exhibit, which was the medical records, were admissible under the theory that that Mr. Miller had no privacy rights or privilege in those. In OVI cases, operating a vehicle under the influence of drugs or alcohol, there's a mechanism in Ohio Revised Code 23-17-022, which sets forth how medical records are to be obtained by law enforcement, not through the prosecutor's office, but by law enforcement, in order to be properly requested and then properly admitted into evidence in the case. At the trial court, none of that occurred. Simply, the records were presented as an exhibit. Over objection, they were admitted into evidence. But what's more alarming is, in the trial itself, at no time did any witness, and there was two witnesses, there was a lay person that apparently came to a scene of an accident that asserted that there was an individual driving a vehicle, not Mr. Miller, did not identify Mr. Miller at any time. And then there was a trooper that came to the scene. Mr. Miller, if assuming he was at that scene, wasn't there at that time. He was directed to go to Akron Medical Hospital in order to determine whether or not that person was there. At no time did any individual identify Mr. Miller as being a driver of a vehicle, being involved in any automobile accident, and simply didn't make any admissions at the hospital either. And then the prosecution in this particular case, in their brief, asserts that it was upon Mr. Miller, who was in the best position to present evidence that he was not impaired and wasn't driving. I didn't understand, in 30 years of doing this, that it was the defendant's obligation to prove a case at trial. It's the prosecution's obligation. They needed to prove that Mr. Miller was impaired. They needed to prove that Mr. Miller was the one driving the vehicle, and they presented no evidence whatsoever to do that.
Well, I believe, and I don't like making their argument for them because they haven't joined us today, but I believe what I gleaned from the argument was they did prove it, and we circle now back to the medical records that you started with.
Well, they suggested that there was circumstantial evidence in the medical records that proved the case.
Okay.
Assuming that the medical records weren't properly before the court,
Well,
then
let's
it
go
didn't
back
prove
to
anything.
that issue. I have a question about
Sure.
that. Were they certified copies of medical records?
The prosecution asserted they were.
When did you get a copy of them?
I did not get a copy until at court. They asserted that they delivered it through discovery to me. There was no evidence submitted to the trial court that in fact occurred.
Well, hang on. If the evidence submitted to the trial court that didn't occur, that would be a pretty significant discovery violation. Did you raise that with the trial court?
I objected to the records and indicated that these records were not presented prior to trial. There was no request to admit the case. You know, one of the cases that the state suggests is this case decision in Tolbert, where in that case, medical records were requested to be admitted into evidence prior to trial, which puts the defense counsel on notice. That didn't occur in this case. The first time the medical records were raised was when they were admitting evidence of, and there was 3 exhibits in the case, where they numbered the records, exhibit number 3, and said, we are admitting this. I did the trial at the lower court. I object vigorously that these weren't presented prior to trial, even if the prosecution had put them in my discovery portal, because I think that was one of their arguments. That doesn't get around the fact that, one, and the 3rd District has kind of addressed this in 2 cases. It's Clark and Little. The third District says that these are information that the defendant has privacy rights, and they do implore the confrontation clause. Now, Judge Carr, you're the writer of 2 decisions out of this court.
The author judge.
The author judge of 2 decisions. But in both of those cases, they were the victim's medical records. They were not the defendant's medical records that were being sought to be admitted into evidence. But more importantly, in both Tolbert and Wooden that you authored, Judge Carr, those cases, there was witnesses, medical professionals that testified as to the records. Whether or not the records at that point may have been kind of ancillary to the testimony of the witnesses, in this case, there was absolutely no witness that testified.
Well,
And the important thing is no.
Custodian of the record.
I'm sorry?
I think there was a custodian of the record that testified. I don't know that you consider that a medical professional testifying as to the actual record.
No, in Tolbert, there was actual medical doctor that testified. What they were trying to get around was that the custodian of the record should have been the person to come in and testify. And in both those decisions, you don't need the custodian of records. Here, we don't have any medical provider that testified. And the most important thing in this case is there was no identification of Mr. Miller. And the state wants to assert that the medical records, he makes admissions. Well, if he makes admissions in the medical records, that's testimonial. Therefore, subject to his privacy rights. And this wasn't a motion to suppress, which is what the state asserts. You don't file a motion to suppress if you don't have the information prior to that this is what they're going to do. This was at the conclusion of the state without presenting to the evidence. And then there was argument to the jury what was in the medical records. And that was improper. And Mr. Miller's constitutional rights were violated up down. We erased 6 assignments of error, although 6 assignment the state did not concedes and so forth. And that's a minor issue. And actually, it concedes as to 2 of the 3 charges. The 3rd charge, which it wasn't really clear at the trial level how the court handled it, but that was failure to control. And if the court granted a Rule 29 in failure to control, there's elements in failure to control that are also in OBIs. It should have granted a Rule 29 on the OBI, which is assignment of error number 1. Even though the state doesn't concede that, but if they concede that a Rule 29 was granted on failure to control, then you don't have the rest of the case as well. So in light of that, I think reasonable minds could have only come to one conclusion in this case, and that was that the evidence was improperly submitted to the jury, and the jury lost its way when it received that evidence.
Counsel, I'm confused as to the Rule 29 on the failure to control necessarily leading to the same result at an OBI. A person can drive impaired and drive perfectly and make it home from whichever bar he or she chooses to drive from. So I'm confused as to how a failure to control has anything to do with that charge.
The assertion in this particular case was that there was an automobile accident on Interstate 77. There was actually nobody that testified that accident occurred with Mr. Willer, but he was charged with failure to control as a result of that accident. If you don't meet the elements of failure to control, which set forth apparently why Mr. Miller came before law enforcement, then you don't have the subsequent charge of an OBI. So if Rule 29 was granted on the failure to control, it should have also been granted on the OBI. This was a simple case that the state could have proved, assuming that they had proper witnesses that testified, i.e. EMS, that apparently transported whoever the driver of that vehicle was to the hospital, or Copley Township police officers that apparently were there at the scene of the accident. Those weren't brought before the court as witnesses to allegedly identify somebody who was in an accident. Identification is ground one of getting past a Rule 29, and if you don't have identification, which wasn't the case in this manner, you don't have anything else. The mere fact that a trooper goes to the hospital and sees some individual that was transported by EMS doesn't create identification. We don't know where that EMS transported the person from, whether or not that was the person and so forth. And therefore, even assuming that something was told to the trooper, that's all hearsay. That's out-of-court statements offered for the truth of the matter. And they, I mean, there was vigorous objections in this particular case. And, you know, trying a case for 30 years, I mean, the court can, with all due respect, hang its head on any of the 5 prior assignments of error, but the most important one is the Rule 29. It should have been granted in this case because the medical records were proper. If the court doesn't have any other questions,
All right.
thank you very much and have a wonderful day.
You as well. Thank you so much for your argument. We'll take the matter under advisement, issue a written decision in due course. It will be mailed to both sides, as well as posted on our website and at the Supreme Court.